There are definitely challenges facing the West Virginia Mountaineers and all other college football programs and college athletic departments around the country. There are even some conflicts between state laws and what could be coming down the pipeline with the new House settlement agreement. Where does it all end? Where do we stand now? And will West Virginia's current NIL laws be in conflict with the House settlement? I brought a lawyer on, an actual attorney who studies this kind of stuff for a living, and who also happens to be a fan of the West Virginia Mountaineers. And we're going to have that conversation with Mr. Travis Knobbe right after this word from one of our channel sponsors. Since 1931, the attorneys at Katz, Cantor, Stone Street, and Buckner have been the voice for victims who have suffered serious injury or death. They have a fierce passion for truth and justice and a sincere compassion for those who have been wronged by others. Whether you have been in a car accident or fighting with an insurance company, or you or a loved one has suffered serious injury or death due to medical negligence, we will ensure your voice is heard loud and clear. Katz, Cantor, Stone Street, and Buckner will ensure there is justice for all West Virginians, because we are your lawyer, your voice. Visit us at yourlawyeryourvoice.com. What is up, and welcome into this episode of Couz's Corner, your home for top shelf college sports news and analysis around the West Virginia Mountaineers and the Big 12. Without further ado, let's go ahead and jump right into my interview with the one and only Travis Knobbe.
All right, we're here with Travis Knobbe with TK Law, who also does some writing for Last Word on Sports College Football. Travis, how you doing today?
I'm doing all right. How about you?
Doing well, man. Doing well. I appreciate you taking the time out of your day to join me.
Absolutely. Happy to do it.
First off, Travis, before we jump into the NIL discussion, which is the main reason I wanted to talk to you today, let's go ahead and get your thoughts on, I know you cover West Virginia for Last Word on Sports College Football there. What are your thoughts on Rich Rod returning to Morgantown, man?
Well, look, I was in law school from 05 to 08, and I attended every home football game with my student ticket in the graduate section, and I saw firsthand some of the best years that the Mountaineers have ever had.
Mm-hmm.
And I'm excited. I mean, it could flame out. His career has not been as good since he left West Virginia, but I think he has something to prove. I think that he has regretted his decision, and he said as much. And if he's got something to prove and he's got that chip on his shoulder, that's what we've been missing, is that attitude. Everybody knows the phrases he likes, but we've been missing that attitude and that sort of hard edge. So I'm excited. I'm excited for what can happen.
Yep. What are your thoughts on the portal movement? I mean, I think they brought in like 50 guys. Are you concerned about that going into year one, or do you think that's just part of the rebuilding process?
I mean, I think that's just part of it. You saw, I know that Dion to Colorado was kind of a special case. But look, they rebuilt almost the entire roster. What was it? 80 some transfers in. So we're not quite to that level. But then again, we also don't have a Travis Hunter and Shedeur Sanders coming with him. So it's comparing apples to oranges. It's not
right.
Not quite as big of a rebuild, but also where the real question is, where's the star power? And I think there are some gems in there in the guys he's brought in. We'll just kind of have to see how it plays out.
Yep, absolutely. All right, man. Let's go ahead and dive into the I was going to say fun stuff, but it's probably the less fun stuff for those of us who are not in the legal world, because it's harder for us to understand. But let's go ahead and talk about the NIL. You have familiarized yourself, I assume, with the West Virginia NIL laws that have been passed. And I wanted to get your thoughts, A, on those and what you think they mean for West Virginia University and their athletic department. And B, how do you think it will, if and when the House settlement finally gets codified, how do you think it will impact, if at all, these new West Virginia laws?
Yeah, it's good questions, and I think I think I'd like to start the presentation on that kind of with with a more generalized look at how this all fits. So, if you think about it and you remember back, it's not that long ago that the NCAA came out and said, all right, fine, we're gonna let players earn compensation for the use of their name, image, and likeness. But we're not going to actually draft any rules that govern this. We're going to have our existing rules, and you guys figure the rest out. That's kind of how the NCAA started it, and really that's how it sits today. I think it's important to remember that the NCAA, it's a national body, but it's a voluntary organization. I think one thing that a lot of people forget is that the NCAA, there's not a federal statute that says the NCAA is created. Way back a while ago, Teddy Roosevelt was concerned with some injuries in football that were piling up and pressured some of the top schools at the time to create the NCAA to set rules on safety. That's how it was born. And then it's become what it is now, where schools organized into first regional conferences, and that now, the patchwork of national conferences. Schools are members of the conferences and of the NCAA, and conferences are members of the NCAA. So if you look at a school like West Virginia, it owes obligations to the NCAA because it has chosen to be a member. It owes obligations to the conference because it chose to be a member of that conference. And it owes obligations to the state because the state has created the college in the first place. And that's kind of where we get into the West Virginia statute and what it means, particularly what it's going to mean with respect to the House settlement. So, I think that's sort of important background for everyone to remember, because it helps to frame and answer a lot of the questions surrounding the statute and the House settlement. Because, even with those things, there's going to be a lot of uncertainty in this world going forward.
Okay. Well, thank you for that. So do you think, can you give the folks from the legal, I've covered the NIL law in West Virginia on my show a couple of times, but can you, from a lawyer's perspective, kind of explain what they mean for West Virginia University's athletic department?
Yeah. So there's two bills. One is larger and more important. The other is potentially more, I don't know if I want to use the word damaging, but it's the one that has probably gotten the more drawn the attention of more writers, because it may conflict with the House settlement and obligations that schools may have. So what I look at is there's two bills. There's House Bill 2576, and then there's House Bill 2595, both signed off on by the governor on April 30. So they're new laws. 2576 is kind of the one that, in my view, allows the schools to comply with House. It has several provisions, but it allows the schools to enter into agreements to pay the players for the use of their NIL. And it actually allows them to do that directly. It also allows the schools to share a portion of the revenues that are generated by athletics. And it gives the schools the ability to condition the payment of those revenue sharing and NIL deals on terms that the schools can establish. In particular, that part of the law really seems concerned with the school is allowed to prohibit certain types of endorsement types and prohibit conflicting endorsements. Best example, not that our players are signing deals with Pepsi and Coke, but if the school had a deal with Coke and the player wanted to do a deal with Pepsi, the school can prohibit that type of conflict.
Gotcha.
It contains a provision too that I think a lot of people may overlook, but it's kind of important for the legal side of this, that the statute specifically says that student athletes don't become employees of the school as a result of NIL deals and revenue sharing. That's been one of the things that's kind of been in the front of at least the legal community's minds, and there have been suits filed about it, about whether student athletes are going to become de facto or real employees of schools now that they're going to be getting all this money. And the West Virginia legislature has said, no, they're not going to be employees, which is, in my view, probably a good thing. I don't think the student athletes should even want to be employees, and I've kind of written about that in 2 or 3 different articles over the last 3 years. 2 other little technical provisions in House Bill 2576 are that the legislature is making sure that the schools aren't taking money from the general fund of the schools that comes mostly from the state legislature and tuition, and paying players from that. It prohibits the schools from doing that to make sure that, you know, the taxpayer isn't the one that's paying the players. And that's, you know, that's pretty important because it doesn't burden an already pretty, what I would consider an overly burdened populace with that revenue sharing obligation. And then to give some teeth to it, it prohibits any organization, including the NCAA and conferences, from investigating the student athletes or making them ineligible because they've received some payments from the schools as a result of either NIL or revenue sharing. And I think pretty much every state law that's been passed since the House settlement first became a concept has included that provision to say, look, we're signing off on this House settlement just like you are, but you're not going to come in and tell our players they can't play because they're getting money from us now.
Yeah, and as part of the House settlement, Travis, there's an enforcement arm that's supposed to be introduced where they can enforce certain, you know, what NIL deals, whether it be rev sharing, and even the outside NIL deals have to go through a clearinghouse. Could that
Yeah.
would that not be in conflict with the West Virginia bill that you just mentioned?
Well, it potentially. I think the bigger conflict actually comes with the other bill that's 2595, because that's the one, you know, similar to, or at least let me back up. So one of the more interesting things about the way the House settlement is going to be effectuated is that the NCAA has already appointed a CEO to run the enforcement arm, and it's going to be a different entity, and you're starting to see the sort of amateurism and like the quote non-business side of college football or college athletics as a whole fall away. So even the NCAA is creating an organization that will be empowered to look at and review these NIL deals that come up in the future. That portion of 2576 may be in conflict if this separate arm declares that an NIL deal is not proper or not authorized and tells the school or the athlete you can't do it. You're right. It is some concern. But 2595 actually it allows the school boards to enter into agreements with corporations that will manage the revenue sharing and NIL contracts. And so just like the NCAA will be creating a new entity, the schools are actually going to be creating entities similar to the Country Roads Trust in concept, but it'll be a separate entity that says, here's the revenue sharing deal, here are NIL contracts, we're going to do that separately, but it's going to be almost a wing of the school. Like it'll be a different entity, but the school will enter into agreements with those corporations.
Right.
And the part that's really potentially in conflict with the House settlement is that the statute specifically exempts from any disclosure laws or public oversight the agreements that the schools enter into with those corporations
Mm-hmm.
and the agreements that the corporations enter into with the student athletes. So if they're exempt and the corporations are allowed to not give those statutes by or those contracts by law to the NCAA's enforcement entity, that's where the real conflict may come into play. That makes sense?
It does make sense, and I appreciate you explaining it better than I could. And then I don't know if you saw this, but the other day an announcement or an article came out. I think it was, it was a national publication. It may have been Ross Downers. I don't remember for sure, but they were talking about how the Power Four conferences are trying to require their schools to sign an agreement saying they will not sue this enforcement arm or sue them for for enforcing the rules of house. Basically saying that any state laws would not apply here is essentially the way I interpreted that. And they're trying to say, hey, if you don't sign this, you could potentially be kicked out of the conference or not be able to play any Power Four schools going forward. I'm assuming you saw that, and if not, what are your thoughts on that? And I mean, to me, that's definitely a conflict. And in that case, West Virginia University would have a decision to make.
Yeah, that's right. And I've seen it and have been following it because one of the, when the House settlement was first announced in the weeks leading up to that initial hearing to approve the settlement, that's one of the things that we heard is that there in various states, not just West Virginia. Tennessee was kind of leading the charge on that, if you remember.
Mm-hmm.
The legislatures were telling the schools, you can, you enter into this House settlement all you want, but if you comply fully with everything that's in that House settlement, you're going to be in violation of state law. So the legislators were threatening the schools and saying there are certain parts of this, particularly this enforcement arm, that you can't do because the state laws allow these players to earn NIL money without any limitation. It's free market, free for all. If the boosters want to pay a player $1 million to sign on the dotted line for Tennessee or West Virginia or Georgia or wherever, they can do it. So that has been a concern for a while, and so now the conferences have started playing hardball and saying, if you guys, like, we have obligations too as conferences, and we're multi-state organizations, so we're not governed by the same state laws that you are. If all of this is going to work, the conferences have to agree, and each of the schools have to agree, and we can kick you school out if you don't abide by what your obligations to us are. So that's why I set it up at the beginning to say and remind everyone, there's the NCAA, there's conferences, and there's schools. Each has a different set of obligations that they have. And I don't know if I hope that's making it more simple instead of more complicated, but the answer is it's actually a complicated patchwork.
Right, because we don't know, and at the end of the day, we don't know. I mean, there's going to be more lawsuits coming somewhere, some way, whether it be from states, whether it be from, obviously there could be former players filing little suits. We know about that, but for the sake of this discussion, I could see a scenario where the state of West Virginia sues this new entity that's being formed for trying to interfere in an NIL deal for a player, for, let's say, at West Virginia, or even Marshall. Marshall's part of this too. Let's not forget. But I mean, could you foresee a scenario like that potentially coming? And do you see those the Power Four conference agreement? Would that supersede state law, or do you think state law would supersede that? How do you foresee that as a lawyer?
I was actually having this conversation in private messages with somebody just the other day. The answer to that is really complicated,
Right.
legally, and like I could get really nerdy about it in a hurry. I won't. I'll save you and your audience that trouble. But just to say that the answer is it really kind of depends. I mean, there's something in the U.S. Constitution called the Supremacy Clause, which everybody might kind of know in passing, and what it means is that federal law passed with constitutional authority, within the constitutional authority that is given to the federal government, a federal law supersedes that of state law.
Mm-hmm.
But the way the House settlement is coming about is it's not a federal law. It's not even a federal court ruling other than to say this settlement is approved. So there's no real supremacy clause analysis to be done. It's a school may have its obligations to a conference, and a school may have its obligations and its limitations as set by state statute. And when those two things come into conflict, you're absolutely right that West Virginia is going to have choices, and sometimes tough choices to make.
Right. Okay. Yeah, that's what I thought. But I appreciate you clarifying it from the legal side and simplifying it for all of us. Because I could see schools like Tennessee and West Virginia, and even the dozens of others who have similar state laws. We could see some conflicts between conferences and their own schools, or at least the states that those schools are in. But I think most of these NIL bills, I think, in my opinion, were done with the schools backing them, and with the schools, in some cases, even lobbying for them. So it'll be interesting to see how this all shakes out.
Yeah, and so that's like the commentary from Ren Baker and Coach Rodriguez have really been strongly suggestive that they've played a big hand in getting these laws passed. And so I think, for now, there are some of our writers and some of our journalists and some of our fans that are a little concerned, saying, well, wait a minute, these things are in conflict with House. But I think they forget that the school has the choice on whether to comply with House regardless what state law says. And I think the reason the schools have lobbied so hard for broader laws than what House allows is because we don't know what's going to happen next. What we can predict based on what's happened the last 5 years is that there is going to be future litigation over exactly how the House settlement works, and there is actually potential. There's even more potential now than there was a year ago that the Power Four conferences break away from the NCAA entirely and create their own thing. So the laws are a little more forward thinking, and even though it creates this potential for conflict, I actually applaud the athletic director's office, to the extent they were involved, and the legislators for coming up with something that gives the room to breathe and expand.
Right. One article I read said that it was a protection in case the House settlement would happen to fall through and not get codified, that these state laws would protect West University and help them out. Outside of the House settlement, if the House settlement, because I guess it's a plan B, so to speak, maybe, just in case House doesn't go through, these state laws would help protect them.
Yeah, and there's a lot of that because the schools, they're signing players, both via transfer and high school players, and they're gearing up, right? They're getting their money in order. They're gearing up to say, we're going to make this obligation or this commitment to each team in terms of how much money we're going to pay the players in revenue sharing, and what we can commit to for NIL deals, all of which is permissible under the House settlement. But what happens if it doesn't go through? You're right. That's a critical question because it still hasn't been approved, and we're, the 100-day countdown has started.
Yep. We thought it would be done by now, but here we are.
Well, justice moves not on our pace.
Exactly.
Right?
Exactly.
I have to tell clients that regularly, that I try to find unique and clever ways to push things along, but I'm beholden to masters just like my clients are.
Yep.
So
we all are.
Same thing here.
Yep, absolutely. Well, Travis, man, I thank you so much for the explanations and giving us your insight from a legal standpoint on these bills and how they may impact House and how they may impact West Virginia University and other schools in the state. But so I appreciate it, man. And again, everybody, Travis, check out his work over at Last Word on Sports College Football, where he covers the West Virginia Mountaineers, and obviously he runs TK Law down in the Atlanta, Georgia area, right, Travis?
I do. Yep.
Okay. So if you're in the Atlanta, Georgia area and you need an attorney, look up Travis. He might be able to help you out. Travis, thanks again, man.
Absolutely. Happy to do it.